Good afternoon, Sarah. Thank you for dropping into the office yesterday. As discussed, I have prepared this video presentation to provide employment law advice to you with respect to your chances of success and what your next step should be. Please note that this advice is subject to reviewing the requested documents, which I will list at the end of this video. We note that the relevant facts are that you're employed by Global Future Vision, which is a multinational company, as a salaried IT specialist. Your employment contract provides for an annual salary, outline of responsibilities, and providing occasional after-hours support as needed. It also has a whole of agreement clause, and there is no overtime or availability allowances provided for under the agreement. Over the past year, Global Future Vision has relied on you to provide after-hours support. Initially, this was only on an occasional basis, but you now provide after-hours support almost daily, which involves complex technical issues. As a result, you are working late into the night and on weekends. We're instructed that you work an additional 15 to 20 hours on top of your standard weekly hours. You advised our office that you made a complaint to your manager that the hours are impacting on your work-life balance and causing you significant stress. The manager states that after-hours support is a core part of your role and covered by your annual salary. The manager then referred you to the whole of agreement clause and as-needed provision. Recently, you refused to respond to a non-urgent request at 11 p.m. pursuant to the right to disconnect legislation. You were subsequently provided with a written warning stating your refusal constitutes insubordination and a breach of contractual obligations. Your manager claims that your salary covers all work performed, including after-hours support, and the right to disconnect does not apply to salaried employees. Pursuant to Section 20 of the Fair Work Act, the standard hours for a full-time workweek are 38 hours. This is also enshrined in the National Employment Standards following the working hours case. The case allowed workers to refuse overtime where the overtime meant that the employee was working unreasonable hours. Under Section 62(1) of the Fair Work Act, an employer must not request an employee to work more than 38 hours per week unless it is reasonable. An employee may refuse to work the additional hours under Section 62(2) of the Fair Work Act. This brings us to our next issue, which is how do we determine what is reasonable and what is unreasonable? Reasonableness is determined with consideration of the factors referred to under Section 62(3) of the Fair Work Act. What is reasonable for one person may not be reasonable for the next. For example, in McPherson v. Coal and Allied, an increase in a mining worker's rostered hours from 40 to 44 hours per week was not unreasonable given the facts. Whereas in Premier Pett v. Brown, a fish keeper was able to establish convincing personal reasons as to why he should not be required to work regular overtime. His dismissal for refusal to work additional hours was found to be a breach of the general protections in Part 3(1) of the Fair Work Act. In the matter of Sagona v. R&C Piccoli Investments, a similar conclusion was reached, where a photographer who was already working 45 to 50 hours per week was then asked to work all hours necessary. In your case, we would submit the following pursuant to Section 62(3) that there is a risk to your health and safety as the additional hours are causing you significant stress. Your personal circumstances have been impacted as you are unable to achieve a work-life balance. Your workplace has high needs. You should be paid an availability allowance for reasonable hours during set times. Alternatively, they could pay you overtime. There is no notice provided to you regarding any requests for work. The calls can come through at any point of the day and you are expected to answer them. You have spoken with your manager about your concerns and the impact the additional hours are having on your mental health and work-life balance. It is not clear if you have raised your intention to refuse to work the additional hours at this point in time. In the IT industry, it would not be unusual for employees to be required to work overtime. However, the relevant award states 38 hours per week. Presumably, after-hours works would only be for urgent work-related matters. You are an IT specialist at Global Future Vision. It is evident that you have experience at troubleshooting complex technical issues, as the company has a heavy reliance on you to do this type of work at different hours. The additional hours are not in accordance with the averaging terms under the relevant award. On average, you do an additional 15 to 20 hours per week. Pursuant to the authority of CFMMEU v Haypoint Service and the working hours case, it would be submitted that the request for additional hours is unreasonable pursuant to the factors considered previously in this video under Section 62(3) of the Fair Work Act. The CFMMEU v Haypoint Services case found the employer to be in breach of its agreement, which moved from voluntary overtime to a blanket requirement of an additional 455 hours each year. Currently, you are averaging an additional 780 hours to 1,040 hours per year. In order to exercise your right to disconnect under Section 333M of the Fair Work Act, the Court will take into account the following factors, which are provided for under Section 333M(3) of the Fair Work Act. Number one is the reason they contacted or attempted to contact you. In your case, they attempted to contact you for a non-urgent request. Number two, the contact or attempted contact was made at 11 p.m. at night, and you may have been asleep at this time. It would likely have caused a big disruption to your personal life, and it would also have disrupted your sleep. Number three, you are not compensated by way of an availability allowance during set times. Your employer states that your salary covers the additional hours. Your work contract states that you will be required as needed. Number four, you are an IT specialist, but you are not in a management role. Number five, your work-life balance has suffered, and you have suffered significant stress as a result of the demands of your employer. Accordingly, you are within your right to refuse to undertake the overtime under the Right to Disconnect legislation pursuant to Section 333M of the Fair Work Act. Under this legislation, you cannot be contacted unless the contact is an emergency or genuine welfare matter. Additionally, you must be in receipt of an availability allowance for the period during which the contact is made. Phone calls are not required to be taken outside of work hours. There are significant health and safety concerns under Section 62 of the Fair Work Act, where employees are not provided an opportunity to have a break. This is clearly impacting you given the significant level of stress you are experiencing. Analogous to Aldi Foods v TWU, where an employee is given an agreement which commits an employee to 38 hours per week, and they are given no right to require a reduction due to personal circumstances or the like, the agreement will contravene the national employment standards. An employee is obliged to comply with any lawful and reasonable direction given by a supervisor or manager pursuant to RV Darling Island Stevedore and Lightridge. Pursuant to the authority of Kelly v Alford, an employee cannot be asked to do anything that is unlawful or unreasonable. Two factors are considered by courts. Number one is the scope of the job the employee has been engaged to do. This can be broad, but needs to appertain to the job pursuant to the authority of Commissioner for Government Transport v Royale. It must also contain a detailed duty statement, though this statement does not need to be exhaustive of duties at that level pursuant to Miller v University of New South Wales. Number two, the proper extent of the managerial authority. You may be able to argue a breach of contractual or tortious duty of care by being expected to work unreasonably long hours pursuant to Johnston v Bloomsbury Health Authority. This case involved a junior doctor whose health might be damaged if he were required to work unreasonably long hours. However, in Kohler v Cerebos, the court rejected claims that illness was brought on by excessive workload. In this case, the employee was hired on a part-time basis to do a full-time load. It was held that the employer could not have reasonably foreseen the impact of the workload. It would be submitted that your employer has breached the general protections afforded to employees under Part 3-1 of the Fair Work Act by disciplining you for refusing to work unreasonable additional hours. The strengths and weaknesses of your case. The strengths of your case are the hours will be deemed unreasonable pursuant to Section 62 of the Fair Work Act. Number 2, you are entitled to a right to disconnect pursuant to Section 333M. Number 3, no break presents as a health and safety risk pursuant to Section 62 of the Fair Work Act. Number 4, you are not required to follow any unlawful direction pursuant to Kelly v. Alford. The weaknesses of your case include there is an employment contract with a whole of agreement clause and an as-needed clause. However, where there is a conflict with the National Employment Standards or the Fair Work Act, these terms can be implied by the court. We would recommend your first port of call should always be to discuss the matter with your supervisor or manager to attempt to resolve the dispute. However, it sounds like this has been attempted and was unsuccessful. Therefore, we would recommend contacting the Fair Work Commission and request a stop order pursuant to Section 333P 1B of the Fair Work Act. Alternatively, the Fair Work Commission can deal with the dispute in other ways, such as by way of conference, mediation, etc. Alternatively, they can attempt both. Stop orders can work both ways, but in your circumstances, it would assist to stop your employer from requiring you to respond to requests and stop the employer taking action in terms of the written notice for insubordination. If you wish to apply for a stop order under Section 333N, the Fair Work Act, or deal with the dispute in another way, you will need to complete a Form 92, which is available on the Fair Work Commission website. We can also prepare this for you should you choose us to represent you. Additionally, you are able to ask another person or industrial association to support or represent you. We can represent you provided we have permission from the Fair Work Commission Australia pursuant to Section 596 of the Fair Work Act. Some of the benefits of attempting to resolve your dispute in the workplace include discussing the matter with your manager can lead to increased confidence in the workplace and a better employment relationship. The issue can be resolved quickly and in terms that are likely to be suitable to both parties. However, the drawbacks are you have previously approached your manager who declined to discuss the matter further, citing your employment contract. The benefits of resolving your dispute via the Fair Work Commission include they will be able to educate your employer regarding the laws surrounding the right to disconnect. They will be able to apply an order against your employer, which, if breached, can incur civil fines. They will decide how the matter is best resolved and offer solutions to both parties. Some of the drawbacks can be it does take time, the decision is taken from your hands, and it can take a toll on your mental health. This is some preliminary advice and is also subject to reviewing your employment contract, any call logs that you have, job requests, timesheets, pay slips, and any other relevant documents which you believe may assist in your matter. In order to substantiate your claims regarding your stress in the workplace, we would strongly recommend that you engage the services of a psychologist if you have not done so already. We will want them to quantify the fact that the demanding hours are the cause of the extreme stress. Lastly, I just want to thank you for taking the time to listen today. After we receive the above documents, we will provide further advice. In the meantime, should you have any further questions, please do not hesitate to contact our office.